Are you gonna
testimony, Mr. Hughes.
There you are.
So that'll conclude the evidence. Plan would be to excuse the jury at this point in time, ask them to be back tomorrow morning as normal. We'd start with instructions at 9 o'clock and proceed on to closing. We'll discuss the details of that after we get the jury out of here, and obviously we need to go over jury instructions. You renew your motion for judgment of acquittal at this point in time, Mr. Prince?
Yes, sir.
All right. If you wish to be heard, I'll let you be heard after we get the jury out of here. Anybody have a problem with that process?
No,
All right, let's have a jury in, please.
All rise for the jury.
Any further rebuttal, Mr. Hughes?
There you are.
All right. All right, so that means you've heard all the evidence you're going to hear. The next thing I'm going to do is instruct you on the law and allow the attorneys to do closing argument. It's too late for us to start into that at this point in time because it's going to, you know, at least, I would say at least 3 hours. And that means you'd be going out to start deliberating at 6 o'clock tonight. I think that's too late to start. So what we're going to do is we're going to have you come back in the morning. I'm going to meet with the attorney, get jury instructions finalized. We've got a draft of that, but I need to finalize them with them. I do give that to you in writing. Then we'll have closing argument. Hopefully we'll have the case to you by lunchtime tomorrow. As I told you before, you need to come tomorrow prepared to stay overnight if that should become a necessity once in a first-degree murder case. Once deliberations start, you have to be sequestered. You'll be able to, you know, call your family members, keep them posted on what's going on, but you're not going to be allowed to go home, and they're not going to be allowed to visit you. We don't advertise where you're kept. That's, you know, it's to kind of keep you separated while deliberations are going on. So just throw a overnight bag in with you when you come in the morning, and we'll proceed from there. Does anybody have questions about what's expected of you? All right. We appreciate y'all being so responsible so far. Let's continue that. We'll see you tomorrow morning at 8:45, same place, same time. All right, everybody be seated. Mr. Prince, do you wish to make any argument on the judgment of acquittal?
I would rely on the argument from the
Right. I deny the motion for judgment of acquittal. Then do discuss jury instructions. Let's first discuss, so I don't forget, I might forget. Let's talk about how long we're going to take on closing. How long do you think you need, Mr. Fuchs?
Mr. Prince and I were talking about it earlier, and I think our closings together were somewhere in the neighborhood of an hour and a half to 2 hours total each. He took, I think, an hour and a half. I think I took 2 hours total, is what he's telling me. But quite frankly, I've never.
2 hours each.
That would seem to me like that would be appropriate.
Don't feel compelled to use it all.
I get a rebuttal. I get caught twice.
All right. So that's good with you, Mr. Prince?
Yes, sir. I won't take 2 hours for that.
All right. I would. Okay. Before you leave today, I want everybody to go through the exhibits. I know usually I do that after I've sent the jury out. Well, but there's so many exhibits. I think you need to do that this afternoon. Get them in some kind of organized fashion. I know they're going to get rearranged a little bit over the evening, you know, overnight, but let's get them to where they're in some format for the jury's use. And what we need to do is come up with a list for them. You know, the clerk probably has a list. You can look over the clerk's list, or y'all can provide a list, but I don't think it's fair to the jury to give them a pile of evidence and not give them at least a list of what we're giving them. If there's anything controversial about the title of it, we can change titles, but let's give them a list of the evidence that's going to them. Hopefully y'all can agree on that. But let's, before you break for the afternoon, let's get that resolved and get the evidence gone through. And if you want to designate, somebody is the person to do that, so be it. But let's not try to do that tomorrow morning, or sounds like maybe tomorrow afternoon, as the jury goes out. Other than jury instructions, anybody else have anything else?
Along the lines of what the court was just talking about, I do have one correction to Defense Composite Exhibit 6. There was no testimony or evidence entered this time pertaining to any of the vehicles. Part of what Mr. Knox's testimony covered last time was an analysis of the green truck. I pulled those pictures out. Mr. Buse has no objection, so those pictures would not go to the jury. So Composite Exhibit 6, instead of going through 6A to 6Q, will go through 6J times 7. That'll be the last exhibit.
6A through 7Js?
Correct, yes, sir.
Okay. I don't know
We
if
also
I've
need
ever had.
from the PowerPoint presentation. Sure. Okay.
What's that?
The PowerPoint presentation had it in as well, and I think they already removed that, so.
So you got that part, so we're gonna give back the ones as to the truck. Okay. Anything else other than the jury instructions? Okay. And I don't. And if you've designated one person to talk about your instructions, the rest of you are free to go if you want. I don't care. But anyway, I don't remember whether there were objections to the instructions last time or not. Are there objections that I need to resolve as to the statement of the charge or the homicide charges?
Do you mind if we start going through the evidence now, or do you want us to wait till the court?
You need to wait. I'm easily distracted.
Yes, sir.
This won't take very long, I don't think.
Your Honor, I don't believe there are any objections. There are some editing things that need to be addressed.
Okay. But I was just trying to remember whether there were any legal objections that I ruled on last time. As they're set out is what the defense is seeking for lessers, first degree, second degree manslaughter. Is that an agreement?
In terms of lessers, I don't recall whether the state wanted those lessers. I don't want any lessers, so unless they want the
Was the
lessers.
state seeking the lesser?
Yes.
All right, y'all remain seated, and this is long. Well, let me turn on this microphone. So, all right, but just speak up well so the court reporter can get you. All right, so what editing are you talking about in terms of the charges, Mr. Evans?
On page
Speak
1.
up now. I'm gonna let you sit down. You gotta speak up. All right, I'm sorry.
On page 1,
Okay,
under introduction to homicide,
okay,
it left in murder in the third degree.
okay. Thank you. We'll take that out. Okay.
And the next would be on page 6. I just wanted, I think, to put on the record there, I think there was an amendment that was done in 2018, but it doesn't appear to affect the 3.212D. And that was the main thing I looked for, Your Honor, was any amendments since we did the trial in 2017. The other issue.
Wait a minute now. I didn't follow what you said. Are you asking to change something on 3.112D?
No, sir. I was just putting on the record, there had been an amendment to that section, but it didn't include 312D. But it did, it was on some other part that did amend.
If it didn't change it, we don't need to talk about it, all right? Okay. Anything else?
Yes, sir. On page 9.
All right, so that's as to the charges. Any issue on any of that, Mr. Brent?
No, Your Honor.
Okay.
All right. The
I
next
have some suggestions on other places, but, all right, go ahead, Mr. Evans.
Okay, on page 8,
All right.
I think we had a question about, we're requesting that number 10 be given, does a witness have a general reputation for dishonesty or truthfulness?
That didn't come up this time because Mr. Washington did not testify, so we'll strike 10. Correct?
There was,
We had requested, because there had been some talk about Mr. Santos, but,
There's no reputation testimony been presented.
okay.
The
it was,
defense,
it was to Mr. Bossio regarding Gregory Washington in that statement still.
we didn't put on any of the Washington stuff.
There was-
Oh, well,
there was
but he didn't testify, so so we'll strike 10. What else?
On page 9, the second paragraph, you've heard the testimony of a child.
Right, we didn't have a child testify, so we'll strike that. We're in agreement?
Yes, sir.
Okay.
And on the bottom of page 9, defendant not testifying.
Yeah. Did we leave that in last year?
I was surprised too, Your Honor.
I don't know why that's there. Anyway, we'll take that out.
And
What else?
I'm, up until we get to page 11 on the verdict, there's a couple things on there.
Well, let's cover what's there.
Okay. There was a 2018 amendment. One was just real minor
What are you
on,
talking about?
under verdict 3.12,
Oh,
the second paragraph.
no,
On the first-
We're not to the verdict yet.
Okay, that's,
You talking about the verdict form?
no, the instruction on page
Oh, okay.
11 talks about verdict.
All right.
There was one minor change that they made, and then one more substantive I want to address. The minor one was on the second paragraph. It says if you return a verdict of guilty, it should be for the highest offense that which has been proven. The term, or the word which has been changed to that in 2018. But I only bring that up, Your Honor, because
Okay.
it was a 2018 amendment. But what
Okay.
we want to add is the new standard instruction that addresses the standard instruction that it's not necessary for the jury to decide whether it's first-degree premeditated murder or felony murder. I think that will only apply to counts 2, 3, and 4, but that was added in 2018.
You're not on page 11.
Bottom of page, well, it would go on page 11 under the verdict. 3.12, and what I'm talking about, Your Honor, is the new part of it. It says, if you return a verdict of guilty to the charge of first-degree murder, it is not necessary that all of you agree the state has proved first-degree premeditated murder, and it is not necessary that all of you agree the state has proved first-degree felony murder. Instead, what is required is that all of you agree the state has proved either first-degree premeditated or first-degree felony murder. And that instruction was added in 2018, and it indicates in the standard instructions it should go after the second paragraph, or after the third paragraph. And I think it would only apply to counts 2, 3, and 4, so it would need to be tailored like you did the other instructions to indicate that applies to counts 2, 3, and 4, since those are the only ones we're seeking the felony murder instruction on.
You got something in writing, what you want me to say?
I got standard instructions. I didn't do the,
You know, if you're gonna ask me to change something, why don't you put something in writing so I can see what you're asking for? It's not, you're not just asking for the standard, you're asking me to give something different. Why don't, I mean, apparently you've thought about this, why don't you just put something in writing so I can see it? Expect me to do the work on it.
what I had envisioned was you would just do like you did on bottom of page 3. It says this
It would have been
theory.
real nice if you put that in writing so I can see what it is you envision.
Yes, sir.
You follow what he's talking about, Mr. Brent?
Yes, sir.
Last paragraph on 3.12. So I'll craft something to add in. What else?
That would be all as it applies to the instructions, Your Honor.
The only other thing I can think of, Your Honor, is the standard instruction. I'm sorry, I don't have the citation newspaper pulling right now.
I'm sorry, speak to the microphone,
Yes,
Mr.
sir.
Prince.
The only other thing that I can think of is the standard instruction pertaining to a cooperating witness who anticipates getting a
It's
benefit
in
from the
there.
state.
It's in there.
Oh, it is, okay.
So there are several permutations of that, but it's the same one we gave last time. It's very bottom of page 8, top of page 9. Witness who hopes to gain more favorable treatment in his
Yes, sir,
own
that's the one.
case.
Yes, sir.
Okay. Only other change I've made is I deviate a little bit from the standard on the submitting case to the jury on, I don't tell them to leave their phones in their seat. I tell them to give the phones to the bailiff. I can't imagine that anybody's real concerned about that one way or the other. All right, so I would take it on the verdict then. The state wants me to take out the interrogatory about whether they've chosen premeditated and felony or the options there.
I don't think the options are on the verdict form I received, Your Honor.
They're on the one I handed out to you. So under counts 2, 3, and 4.
Oh, okay, I'm
not-
sorry,
not
Your
on
Honor.
one. So you're telling them it doesn't have to be unanimous on which they're choosing, then that interrogatory is wrong then.
I don't think it's necessary, Your Honor.
It's more than not necessary. It's never been required, but it was something that Ray Markey convinced me to include. But if it doesn't have to be unanimous as to their theory, then it's actually wrong.
Under these set of circumstances, I would agree with that, Your Honor.
Prince, you want to be heard on that?
I don't think it matters much, Your Honor. I mean, Mr. Fuchs is going to argue it's premeditated first-degree murder, and I'm going to say the same thing, so it doesn't
Well,
matter much.
I mean, the import of it is that you could have a split in the jury, 3 thinking it's premeditated murder, 3 thinking it's felony murder, and that would be a unanimous verdict under the new instruction.
I don't disagree that that's the law.
Okay. All right, anything else? Did you have anything else, Mr. Evans?
Your Honor, it's more of I think legally, I think we probably should add under, like on page 1,
You're on the verdict now?
on the verdict,
Okay.
where, and this would apply to each time we ask this question, but during the commission of the offense designated above the defendant, I think it probably should read actually possessed and discharged,
That's not right.
as opposed to just
That's not what the statute says. I've heard you suggest that before, but that's not what the statute says. All right, anything else?
no, sir.
Not from the defense, Your Honor.
All right. All right, so I'll make those changes. I want to be able to start right with the jury at 9 o'clock. How do y'all want to get the, and then there's only a couple of substantive changes, but there are a couple. How do y'all want to get them so we can be certain whether there's any further argument to be made?
8:30 tomorrow morning.
What's
Yes,
that?
8:30 tomorrow morning?
If you want to email them, Your Honor, to Mr.
Yeah.
Prince and myself, and then we can,
I mean, 8:30 works if we don't have anything else to discuss and I have time, but we need to, print them and collate them. Why don't I do this? Why don't I'll email them out to you and everybody reply to me. If somebody finds an error or has an objection, I don't want to get into making legal arguments, but if it's just a typographical error or something, let me know. I'll fix that. If somebody wants to be heard legally, we'll do that at 8:30. Otherwise, I'm gonna print them out and be ready to go. Okay?
Yes, sir.
Yes, sir.
Who do you want me to send them to?
Myself, Your Honor.
And me as well, Your Honor.
If you don't mind, Your Honor, can you include me in that, please?
Okay.
Thank you. I know you will.
Do I have your email address, Mr. Prince?
Ms. Reisinger does, Your Honor.
What's that?
Ms. Reisinger has it.
Okay, all right. Anything else from anybody?
No, Your Honor.
No, sir.
All right. See y'all at 8:30.